Today's talk is part of our Conversations in Forest History webinar series. Our guests today are Sam Cook and Mavis Gragg. Sam is the Executive Director of Forest Assets and the Vice President of the Natural Resources Foundation for the College of Natural Resources at NC State University in Raleigh, North Carolina. Mavis Gragg is an attorney in Durham, North Carolina, and she is the Director of the Sustainable Forestry and African American Land Retention Program for the American Forest Foundation. And with that, I'm going to turn things over to them.
Thanks, Jamie. And Steve, our Executive Director for Forestry Society, along with your staff that's helped provide this opportunity for the people out there in the airway. We appreciate this opportunity to present a Hanover seminar series, and it's nice for me to be back again with this esteemed group of people today. When Jamie approached me about the topic, I couldn't think of any one person to help pull this off today. Also, in that person is Mavis Gragg, who's on the screen with us. Mavis and I do this work quite often, and it seems like sometimes it adds up to be once a month. We've been doing it for a while, and I met Mavis back in 2016, and we started presenting on this particular topic. I really hate that it's virtual, but I think, as we discussed before we started the webinar, this allows more people to participate from all across the globe. Slide one, Mavis, please. So Jamie mentioned that we can spend all day talking about who we are. You can take a moment to read through this, and this will tell you who I am. Just to be clear, I am Sam Cook, and I'm at the NC State College of Natural Resources, and I serve as our Vice President for the Natural Resources Foundation and the Executive Director of Forest Assets. And I currently serve on this board as well for the Forest History Society. Mavis and I are here to talk to you about some ongoing learning topics that there is a lot of interest. And I feel like we need to make sure that we touch bases on some of the topics that we'll be covering. We will not be able to educate you fully on how to handle heirs property in your area, but we will be leaving you with enough information that you'll know, one, probably who to call on, but have some talking points when you start asking questions. So our job today is to provide opportunities of learning about heir property and land utilization. So our goal today is to address these following items. Heirs property issues: who owns what portion of lands passed down without wills? How have heirs property issues contributed to land loss among African Americans? Just to addressing issues with heirs property ownership and practical steps for stabilizing heir property owned land and land utilization for inclusion, which in parentheses is conservation easements, carbon, solar, agriculture, forestry, and ecosystem services. All opportunities for landowners, whether you have heirs property or clear title. There'll be some distinct differences as you own heir property versus owning clear title, but it will give you a concept of how you move forward with helping to make your decisions on your land. So a little bit of historical context. Between 1910 and 1997, African Americans lost about 90% of their farmland. It was a major contributor to America's racial wealth gap. The median wealth among Black families is about 1/10 of what white families. Now, as reparations have become a subject of national debate, the issue of Black land loss is receiving renewed attention. A group of economists and statisticians recently calculated that since 1910, Black families have been stripped of hundreds of billions of dollars because of lost land. Black farmland, which peaked in 1910 at 16 to 19 million acres, has decreased to less than 3 million acres today. And that number is a plus and minus because no matter who you listen to, it can go up or down. Land is one of the greatest and most valuable assets for not only African American farmers, but for all farmers, and basically for African Americans, for them to possess. The cause of underutilization and loss of rural Black land are numerous and complex, but none is more notable than heirs property. Heirs property is created when a landowner dies without a will, and you'll hear a lot more about Today, it is estimated that over 60% of all Black owned land is heirs property. Now, my topic is really focused on forestry as it relates to land utilization. But most importantly, you're going to have a class from Mavis that when you leave or when we finish today, you'll know a lot more about Heirs Property than you ever thought you would. But she may give you a test at the end, so listen up very closely. Mavis, my colleague and friend, take it away.
Thank you. Happy to be here. Excited to connect with foresters. I am an attorney who cannot work slides, but yeah. So I'm the CEO and co-founder of AirShares, which I'll share more about later. I'm also the director of the Sustainable Forestry and African American Land Retention Project that is administered through the American Forest Foundation. But essentially, I'm a death and dirt attorney who works with families to plan for succession of ownership of their family real estate and also address issues that make it challenging to retain ownership of their family real estate. I chair North Carolina's Parks and Recreation Authority, and I also am a former chair of the Triangle Land Conservancy, which is based here in the Research Triangle Park area of North Carolina. So Sam and I, as we mentioned, get to work on some really cool stuff together, a lot of intersection of various areas, forestry, environmental justice, conservation, et cetera. But yeah, we're gonna go to law school for a little bit, and hope that doesn't scare people away. I will talk about what heirs property is and how it works from a legal perspective, and I'll ask you to participate in the discussion by providing your responses in the chat box. I think it'll be fun. It will not be unpleasant like law school actually is. So let's get started. Heirs property really refers to land owned by multiple people, each of whom inherited their shares. And I think that's important to know, that it really is just real estate owned by families who are retaining ownership through inheritance. And Sam has already talked about some of the origin of issues around heirs property, but for many families, maintaining ownership of real estate through inheritance has been a way to preserve family wealth over generations. And in particular, communities that have been vulnerable to violence and injustice in our legal system, maintaining ownership through inheritance was a better way to protect their property and not raise visibility about their owning the property. However, the legal structure of heirs property actually makes owning the property more difficult. It creates a lot of challenges, some of which can result in land loss, but many of which result in undermanagement of the property. And so we've seen significant loss of family-owned real estate because of how they own the property as heirs property. I think it's important to be on the same page about how ownership of real estate transfers. There's two ways to transfer ownership of real estate. So that's going to be your first question. What are the two ways in which you transfer ownership of real estate? Don't be shy. We got what, 40 some people, 73 people. Wow. I know not all of you are. Okay, yeah. So inheritance and sale, I'll unpack that a bit more. Sale, when there's a transfer of property as a result of a sale or even as a gift, there's a deed involved. So the two ways to transfer ownership of real estate is through a deed. A deed is a legal document in which it explains who the current owner is, the grantor, who the new owner is going to be, the grantee. There's a legal description of the property. It's signed in front of a notary, and then it's recorded. And it's recorded and becomes a public record of the ownership transfer. And that's awesome because we can establish paper trail of ownership of the property. The other way to transfer ownership of real estate is to simply die. So any of us who own real estate at the time of our death, that ownership transfers automatically by operation of law. So whether you have a will or not, if you die personally owning real estate, that ownership transfers by virtue of you passing. And that's important because when we're talking about families maintaining ownership across generations as a source of intergenerational wealth, the ownership is typically transferring by virtue of people dying. So property does not start off as heirs property. Typically we have what we would describe as an original owner. It's an individual or maybe it's a couple. For today, let's imagine that we have a married couple and they purchase 40 acres of land that they build their home upon, and they have some trees, they have a forest, they have some, they grow food. Let's also imagine that our family has 4 children. The couple has 4 children. All right, so based on your understanding of the law, when the first spouse passes away, who becomes the owner of the 40 acres? Again, using the chat box, what is your understanding of how the property ownership transfers when the first spouse passes away? The living spouse, yeah. So the surviving spouse retains ownership of the property. They become 100% owner. And that's because in all states, when married couples acquire real estate, there's a specific bundle of rights that provides for survivorship when the first spouse passes away. The property goes to the surviving spouse. Now, let's imagine, remember we have 4 children. Let's imagine that all the surviving spouses passed away and they did not have a will. Who gets the property and what do they get? Split into 4, okay. All 4 children become tenants in common, okay. All right, okay, great. Yeah, so they each get a 1/4 undivided interest. I keep promising, and Sam, I'm gonna hold you accountable for this, to hold me accountable. We need to get Stevie Wonder some new siblings. But let's
just thought you
imagine.
enjoyed seeing him there.
Yeah, so with the property passing through inheritance and there's no will, the law informs us that the 4 children get a 1/4 share, an equal interest, an undivided interest. And this means that they each are entitled to use the whole 40 acres. They each are financially responsible, proportional to their share. They also are entitled to receive income from the property if it produces income, proportional to their share. So that's important. As the property passes on to the next generations, the bundle of rights changes. And I appreciate that someone mentioned tenants in common, because that's exactly how they own it. And I'll talk more about that legal structure in a bit. So if we think about a family tree and the ownership of the property let me back up. When we think about the ownership of the property being retained through inheritance, it necessarily mirrors the evolution of the family tree. And this is a very typical American family tree. At the top of the box, we have our original couple. They're in the blue boxes, and then their 4 children are below them. The yellow boxes represent some spouses. So 3 of the 4 children got married. The peach colored boxes represents children or grandchildren. And then there's even some great grandchildren. And that's very normal. Families grow. It's also common that people pass away. So everyone who has an X in the box has passed away. If we imagine that they passed away in order from the top to the bottom, and that, like most American families, there was no succession planning, there was no trust, no wills, etc. It was simply passing through inheritance laws. How many people, based on your understanding of inheritance laws in your state, how many people do you believe are owners of the property today? So again, using the chat box, let me know how many owners you think there are today. Any guesses? 1, 15, 15, 12, 15, 11. So you're proving one point that I want to make, and that's that we have different views on how inheritance works. And that's common among families. If the 79 of us were family members who own this property or have some connection to this property, we may disagree on who owns the property. And just think, if we had to make other try to make other types of decisions about the property, it could get contentious. I used North Carolina laws to interpret who became owners of this property. And in my interpretation of North Carolina's inheritance laws, there are 16 owners today. So we went from 2 owners to 1 owner to 4, and now we have 16. And that's significant because again, how the property operates from a legal perspective. Here are the set of laws that I'm referring to. So every one of us has an estate plan. Now, you may not have a will and some power of attorney documents, et cetera, but if you don't have those documents, the government has a plan for you. And for transfer of assets after someone passes away, the set of laws that we rely upon are called intestate succession. And in North Carolina, this is how intestate succession works. And it's pretty straightforward, but then it gets messy because in North Carolina, a surviving spouse could inherit real estate with the parents of their deceased spouse. You have no control over who becomes owners. It just depends on who survives the deceased person. And so the informing of who is going to own property in your family when you're maintaining it in this way can lead to a lot of unpredictability about who owns the property and what rights they have. Thank you again for the person who mentioned that they own it as tenants in common. Tenants in common is a very specific bundle of legal rights. Married couples have a different bundle of legal rights. Again, they are able to have survivorship rights. Tenants in common do not have survivorship rights. Any owner who, any family member owner who dies owning their property, their share goes to their heirs. And again, it typically means that the number of owners is multiplying. Any owner also has the right to seek property division or transfer their share in the property. So of course, the family owners, the co-owners could agree to physically divide the property, but any of the owners could also petition the court to force the division of the property. And the court, what they're looking at is whether the property, based on the number of owners and the characteristics, the physical characteristics of the property, including the size, the natural resources, et cetera, if that property can be divided equitably, then the court will physically divide it. But if it cannot be divided equitably, proportional to every owner's share, the court has to force the sale of it. And so then that's where we get into this danger zone of land loss, because third parties will acquire a share of heirs property, and it doesn't matter how big of a share, but they'll acquire a share of property and then seek through the court system a partition sale so that they can become the owner of the property. Another aspect of the legal structure is that it requires unanimous decision making. And again, you know, now we have 84 people on here. We may be able to reach a unanimous decision about who's going to win the Best Picture and the Oscars next week. Doubt it, but we may be able to. But when it comes to family property, it's very, very, very difficult to make decisions about the property. And so the families are really handicapped. So the legal structure necessarily creates challenges. There are also social challenges with owning family property. I'll be generous and presume that all of us are part of a family. You know, we don't necessarily want to do property management or sharing expenses with family members. Families are dynamic. There's always a jerk in the family or two. The other thing is that the financial responsibility. You don't have control over what your share is, you know, what you inherit, but you are responsible proportional to your share. And you may not have the capability of supporting your share. And that often causes challenges for families with heirs property. Excuse me. So, I do want to pause before we turn to solutions or strategies and check in with Sam. Is there anything you want to talk about the structure, Sam, or the challenges?
For me, I think most times when you're talking about challenges, especially for landowners just dealing with their property, it's the obstacles that they have to go through. One being applying for a farm and tract number, which is an opportunity to treat their land as if they can still operate in the same vein as people with clear title. The Farm Bill, this 2018, allowed landowners to now take advantage of applying for a farm bill for a farm and tract number, which also provided them the opportunity to go and apply for a financial assistance program through FF Farm Service Agency and Natural Resource Conservation Services. It allows them to sit and be at the table with other landowners as it relates to carbon or as it relates to ecosystem services. But when I look at a challenge, and if they're not equal, what we need to be able to do is help figure out, especially going into the next 2023 Farm Bill, what are some ways we can have landowners that have heir property become equal to landowners that have clear title? Thanks for the opportunity, Mavis.
Of course. So as it relates to succession planning, again, most families that are retaining ownership of real estate across generations are doing so through inheritance. So their succession plan is inheritance, simply people in the family passing away and their ownership shares passing to their heirs. We believe that a better, more comprehensive strategy would be to do succession planning that is looking not only at the ownership succession, but also the stewardship succession, the management succession of the property. And in my view, the best way to do that is by retaining ownership in an entity rather than in human owners. So the ideal is that the family property will be owned by a trust or a limited liability company or some other type of business entity. And then the governance of that entity informs how the property is managed, who benefits from the property, how the property is used, how income is managed, etc. So that's the ideal. For many families, because they have maintained ownership over multiple generations through inheritance, there are quite a few steps or some significant steps that must happen first before they can actually put the property into an entity owner. And by that, I mean they need to clear title, which I'm sure you all are familiar with. And with family real estate, the way in which we clear title is a bit different from standard title search. For family-owned real estate, we're typically trying to trace title through the family tree. So my recommendation when I'm talking to families and even service providers is that they build a comprehensive family tree that begins with the original owners of the family property or the last deed of record, and include in that family tree not only the names and the relationships, but also for every family member who has passed away, identify when they passed away and what state and county they passed away in, because along with identifying the family members, we'll also need to source the documentation to create a paper trail. And so knowing when people died and where they died will help inform that particular discovery. But once there is a comprehensive family tree, it's important to then go to an attorney whose job it is to confirm who the current legal owners are. And that's significant because those owners are the ones, those family members are the people who need to participate in the decision-making process and the discussion about the different opportunities and strategies the family can take, including an entity-centered strategy. It also is an important point to discuss who will continue forward having a relationship with the land. There are a number of people who own heirs property that, one, don't even know they own it, but two, don't have an interest in owning it. And so it's important to identify who should continue owning and how to resolve any of those who do not continue owning the property or being connected to the property.
Quick question, Mavis.
Yeah.
Quick question.
Sure.
When you talk about the ownership, and most people are thinking that the law is the same across all the states.
Yeah.
Can you spend a little bit of time about that as it relates to heir property ownership in each state?
Yeah, last year I did a 50-state survey of inheritance laws. So I looked at inheritance laws in all 50 states plus DC to understand what happens in each state. And that was a lot of fun and hard to do, but it's fascinating because every state, so real estate ownership and inheritance of real estate is state level legislation. It's not federal. There's no like national standard. And so every state has its own unique set of inheritance laws. And it's pretty fascinating to look at how they vary from state to state. And if I may, I will say there are certain trends in the South, there are certain trends in the West. The middle of America, in my view, gets it right. I mean, maybe they've had a longer history of succession planning with family real estate because their legislation seems to make it easier. But it varies from state to state. It also varies within each state. It varies depending on the relationship to the deceased person. Typically when someone, or not typically, in all cases, the first people we look at or look for are spouses, surviving spouses, and surviving descendants. And what the spouse get really varies depending on whether they're the first spouse or second spouse, or whether they have other kids. Like, it depends on the state, it depends on the relationship, etc. So it's hard to predict who is going to be the owner, because, you know, one thing we definitely don't have control over is when people pass away, unless you're a murderer, but that's a negative topic. But anyway, does that get at your question, Sam? Maybe.
Yes.
Thank you.
Thank you.
All right, so of course there are alternatives to a single entity strategy. You could maintain the current situation. You could do what we call a tenants in common agreement. So this is a contract between the owners. It's still important to identify and confirm who the owners are so that the contract is valid, that it's signed by all the right people. You could, of course, partition the land. So a partition, again, is a physical division of the land. And for many families and attorneys counseling families, that is viewed as a great resolution. Just divide it up. But I imagine that most of us on this call who work in the forestry and green space know that fractionization of land, particularly agricultural land and land rich with natural resources, can greatly diminish the opportunities for resiliency and for industry, et cetera. So we don't recommend physically dividing the land. And we also don't recommend people using the court system to determine whether the property should be divided, or whether and how the property is sold at auction, because again, that diminishes the ability to steward the natural resources of the property, but also to, you know, it diminishes the economic value of the intergenerational wealth. One other alternative that I haven't mentioned up here is deeds. So a lot of people, remember, a deed is a legal document that's used to transfer ownership. A lot of people believe a deed is a method of succession planning, meaning that someone might do what we call a life estate deed, where the grantor is transferring the property to their heirs. So maybe a parent is transferring the property to their children and retaining a life estate interest. And there are many professionals, foresters included, there are many professionals who say, oh, this is a very affordable way to pass your property on to your kids. But as someone who has worked with families to resolve issues with their property, I'll tell you that is not a succession plan. And it's very dangerous because we can't control what happens to people's lives. I had a family that approached me a co-owner, whose mother had transferred the property to him and his two siblings and retained a life estate for herself. Sometime after she went into long-term living with Alzheimer's and lost her legal capacity. His two siblings passed away, each of them survived by a spouse and minor children. And so in one action, the property became heirs property, and you had at least 6 owners who were who had no legal capacity. This is not something that through a life estate deed, the original owner could have planned for. What they should have done instead was put it into an entity that planned for succession, an irrevocable trust, for example. Just to give you an idea about the amount of heirs property there is, we'll look to our state of North Carolina. The Winston-Salem State University's Spatial Justice program and Wake Forest Law School Environmental Law Clinic worked together to produce this map that gives us a guesstimate of how much heirs property there is in North Carolina. So this is not 100% accurate, meaning that they sourced data and made some assumptions based on trends or similar characteristics across our 100 counties. But the red indicates property we believe is owned as heirs property, or the proportion of property in those counties that's owned as heirs property. And then it's overlaid with data around where African Americans live in North Carolina. And so you can see some interesting details here, especially in the areas where there is a higher proportion of African American residents and a lot of heirs property. And I want to point out something that Sam mentioned earlier, is that for many African Americans who were able to acquire real estate after slavery ended, they were still subjected to a very violent and unjust legal system, and maintaining inheritance, maintaining ownership through inheritance without, doing the estate administration process or having wills actually helped them keep a low profile in terms of their ownership away from even governments, local governments. And so I think it's important not to fault families for having this complex ownership, or communities for having a higher proportion of this kind of ownership, because our history and our legal system, quite frankly, have made it very difficult for families of all races, economic status, et cetera, to retain ownership over generations. But going back to this map, let's also think about other intersections of interest. So this map is a map produced by the Southern Environmental Law Center, where they are highlighting where there are coal ash sites, proposed pipeline that's no longer proposed, Enviva wood pellet plants, flooding. Now, if you work for Enviva or work in the wood pellet space, you probably know that Southern Environmental Center sues companies that do that. And that has to do with the production of the wood pellets. And so for SELC, they were looking at what are the areas of high threats. And I think that there is an intersection with the proportion of heirs property owned, at least in the eastern part of the state, and where there are communities that are burdened by waste. We can certainly also look at other maps, and I would encourage you and your organizations to consider the role that you could play, particularly to the extent that you use mapping. Wouldn't it be wonderful to look at heirs property and climate resiliency, heirs property and family-owned forests, et cetera. So Sam, I'm going to ask you to talk about the incentives to address the legal challenges.
Some incentives to address these issues are really related to the work that we do in forestry and other entities that operate in the agricultural space. Primarily is to try to bring income to the landowners, to help them, one, in the financial help to support the landowner, as much as the outreach piece, but the legal issues that goes along with solving the resolution piece. And there are tools in conservation, but I go back to the ag side of the business. The farming community has always been a pretty big group working with USDA. Where they were limited was in the forestry sector. And so you'll hear more about the Sustainable Forestry African American Land Retention Program. Mavis mentioned this earlier. It unleashed the opportunity for African American landowners, but also other historically underserved landowners, to now understand what forestry could do for them on their land as it relates to managing land. And my approach has always been, when I do the extension piece of what we did in the SFLR project sites, if you go to a landowner and holistic from the standpoint that they may be growing trees, they could be growing some type of agriculture crop, but they also may have vacant land that needs something on it. So talking to the landowner with a plan that allows them to look at every inch of every piece of the land, entire plan together with that. Conservation agencies like USDA and other natural resource professionals, they provide the same outcome and opportunities, and they work very close with landowners, not just heir properties, but all landowners. We need to be thinking now that we have all these carbon groups, organizations in play. How do we help landowners that have these small acres take advantage of carbon opportunities? There are a lot of projects out there in play right now. I won't name one because I may leave someone else off, but those programs will allow landowners to now see that there is another financial benefit for them owning land. Helping landowners understand intergenerational wealth and stability. I'll give you a quick story around that. I had one landowner family that was 4 sisters. They spent time managing their land, but they never had an opportunity to really understand the forestry side of it. They heard me in a workshop one day talking about some of the opportunities for them, but they were approached prior to coming to me with someone trying to buy the timber off of 267 acres. They in turn was offered $90,000. 1 week later, they received another offer of $190,000. It threw a red flag to the first sister. She called, she came and visit. I said, give me 30 days. I took a consultant to sit down with her and the other 3 sisters. Guess what? They all had about 3 to 4 sons with families that would not take the time to come sit down at the table to listen to this project. We ended up about 30 to 45 days later, getting that family $430,000 for the timber sale. They gave USDA, and USDA provided about $140,000, $180,000 for financial assistance to help them reforest land. So the trees were able to be cut and they were able to get funds to put money back in the ground and put trees back in the ground. But the point to the story is this landowner, they ended up finding out that they had Heirs Property. They were working with the Center for Heirs Property Preservation. They were already enrolled in their program. They were able to use Facebook to find one of the owners that was not connected to the family, and it was a kid over in Taiwan. They finally resolved the Heirs Property issues. They were able to sell the timber and they were able to get money from USDA. And it allowed them to showcase that from using a consultant, a professional forester to help them manage it, gave them a better outcome. But the key piece to this, once the kids and other family members found out how much money they made, they in turn start calling me asking about what is the next harvest looking like. And we were able to give them some projections. So now that family is able to pass down the land and the money, which the kids did not want the land early on because they saw it as a barrier and they did not see it as an asset. We think about things of gaining access to resources, that's disaster recovery. Heirs Property owners have a hard time because they cannot get results from FEMA. They don't have a way to get funds from FEMA. So when big disaster hit, they are struggling to recover. So there needs to be ways that we can improve on that. And I think there's some discussion for the next Farm Bill to help solidify that. And always confirming legal standing, which is to address the environmental justice issues. You just saw that in the map. We're not saying that everywhere that you saw on that map is an environmental justice problem, but we are saying that we need to help landowners that are living in those spaces see what opportunities other than just ag that can help benefit them for owning the land. And our conservation groups typically can help from conservation easements and other opportunities as well. Go for it, Mavis.
Yeah, so, and I guess Sam, you and I could both talk about some initiatives, and you kind of already touched on a couple of them. So initiatives and policies that support Heirs Property preservation include the the Sustainable Forestry and African American Land Retention Program. This program we'll learn a bit more in a bit. AirShare, so that's a company I co-founded, as I mentioned before. We are building technology solutions that make it easier to build the family tree that's needed to trace the ownership. And that way, when the landowners are working with attorneys, they can do so more affordably and more efficiently. And we're also building tools that facilitate management, co-management of the property, and then an educational platform. So stay tuned for that. But if you want to join our newsletter, go to airshares.com. There's also the Land Loss Prevention Project. This is a nonprofit law firm based in North Carolina that has done significant work since the 80s on behalf of Black farmers and represented a significant number of farmers in the Pickford case. We have the Uniform Partition of Heirs Property Act. So again, partition actions are standard. They are they happen in every state. Typically, they provide for the for the physical division of the property, so partition in kind. And then if it can't be sold, or if it can't be physically divided equitably proportional to everyone's share, they have to do the sale, a partition sale, which is similar to a foreclosure auction. The property is on the auction block and typically yields much less than market value. The Uniform Partition of Heirs Property Act provides for partition actions involving heirs property, an extra layer of due process rights for the family members. One big thing that it requires is that the petitioning owner must first provide their share or first right of refusal to the other owners. So the other owners have the right to buy out the petitioning owner. The other aspect or important quality of that legislation is that it requires the property to be sold at fair market value and in the private market. So this will help address that economic loss when heirs property is being sold in the sold through a partition action. And then, as Sam mentioned, we have the Farm Bill of 2018. This is the first Farm Bill that talks about heirs property. It provided for the eligibility criteria for heirs property owners to obtain a farm and tract number. It also provided for this heirs property lending program in which the USDA secretary would provide loans to qualified community development financial institutions to then reloan money to landowners, heirs property owners, to do succession planning, to resolve title issues, etc. And as Sam mentioned, Farm Bill 2023, there's some room for growth and improvement. In particular, our hope is that we can be successful in unlocking those dollars for the loan program to be managed or stewarded through a grant program or even a forgivable loan program. And it's not listed here, but the eligibility criteria for individual assistance for FEMA recently changed in September of last year. I think that that's great. And I think that it'll be very difficult for families to provide the documentation necessary to prove ownership under the criteria. And so I think that's an area in which this profession could actually aid owners, particularly those that are in areas that are frequently hit or regularly hit by natural disasters. You know, talking to your landowners about their, whether they have heirs property and, should there be some disaster damage, do they have the ability presently to prove ownership? Or is that a goal that they can set at the same time they have their goals under their forest management plan, gathering the documentation that is needed to qualify for individual assistance under FEMA? Sam,
one thing to add there, we talk about the 2023 Farm Bill. The call to action for the people that's on this webinar is find out in your state or around you the organizations that are helping to rewrite the Farm Bill for 2023. And learn what ways you can help advocate for the changes that we're talking about today. And second, this goes probably more on your level, Mavis. Everybody out of the 84 are not all foresters. We have a wide breadth of individuals from all different careers. And so we need to advocate for not only just in the forestry community, but to take an opportunity to look at it from a landowner perspective for what ways you can help us improve landowner outcomes as it relates to owning land, whether it's on the heir property or clear title. Thank you.
Thank you for that. Someone mentioned, I just checked the chat, and thank you all for putting comments and questions in the chat, and we'll encourage you to use the Q&A as well, and we will address questions at the end. But someone mentioned pension funds buying heirs property using this partition strategy, and that's true. So another initiative or policy type activity, I think that particularly landholding companies and organizations could take is in their corporate sustainability policy, providing some measures that do not enhance or drive land acquisitions through vulnerable land holdings, meaning heirs property owners. Perhaps make it a policy to not acquire heirs property unless, insert some condition, unless you're paying market or above market or something like that. That was a little side point that I will have not made before, but since someone mentioned TIA CREF, that is true. It's my understanding that they were able to acquire a great deal of land in the Delta region through partition actions or just simply buying heirs property. Okay, so a little bit about SFLR, and I'm going to invite Sam to share his own experience because he was one of the original pioneers as part of the SFLR program. But essentially, the Sustainable Forestry and African American Land Retention Program is driven through a partnership of organizations that include the U.S. Endowment for Forestry and Communities, which is the founding organization. A network of 8 Black-led, community-based organizations that deliver the on-the-ground outreach, education, and technical and financial assistance to the landowners enrolled in the program, as well as NRCS and the U.S. Forest Service and a couple of foundations, and then the American Forest Foundation. The endowment created the program in 2012, and then the administration of the program transferred to AFF in 2019. And so our role is to co-lead the program with the network of 8 anchor organizations. We do fundraising, policy work, communications, etc. Sam, is it okay if I say a little bit more and then you jump in?
Yeah, take it away. This is your job.
Okay. That's true. I am the director. This map, most African-American ag land is owned in the southeastern United States, and the map on the left shows that, and then our program is in 8 states. This map only has 7 of the 8 states, so add Texas on there, but we're in Virginia, North Carolina, South Carolina, Georgia, Alabama, Mississippi, Arkansas, and now Texas. And the organizations, the 8 anchor organizations, are very unique. We have 2 universities through their cooperative extensions. We have 2 landowner cooperative organizations in Alabama and Mississippi, which is a very common practice among African-American landowners in the Deep South. They would form cooperatives as a way of getting better access to markets and better access to services. And then we have a land trust, a non-land holding land trust, an organization that started off as a nonprofit law firm that now has a staff of, I believe, 7 or 8 foresters. And then we have an economic development organization in Georgia, and then an electric co-op in North Carolina. And I personally find it fascinating that we have such a variety of organizations that participate in this program. I do think it demonstrates the expansiveness of how this issue can be addressed through a variety of organizations that have their own unique approach to this work. But yeah, I'll pause there and Sam, invite you to talk about your own experience with SFLR because you were there from the beginning.
So got engaged in it in 2012 when the RFP came out across the South with 17 organizations. And 4 organizations, 1 in Alabama, 2 in Alabama, 1 in North Carolina, and another in South Carolina, were identified to pilot the program to see if what we did on the ground with landowners would make a difference for them to own the land and retain the land, and also how does it flow over into them help working to achieve clear title. We were very successful in proving the outcomes, identifying ways that landowners could improve in their income stream. But I think most importantly, we were able to demonstrate to the endowment, along with the other 2 partners, the Natural Resource Conservation Services and the Forest Service, that if resources were there, boots on the ground, and landowner education would provide landowners a pathway to kind of hold their hands early on, but deliver on a process that landowners can walk away from the program and start inviting others to join. You heard Mavis mention the center. Part of my work was with the Center for Heirs Property Preservation from 2013 payroll-wise up to 2016. We were successfully proven the pilot within a 1.5 years, and that allowed the endowment to go back to their board of directors to request more funding to support this pathway to how it actually got to the AFF. There was no plan in sight to spread it beyond those 3 states. but it became so successful that NRCS, married along with the Forest Service and other entities, said, let's see if we can find other states to participate. And so those 4 or 5 other states that Mavis mentioned gave them an opportunity to say, this is important for us to continue to work. She did say that it's different. It kind of go back to the concept of when I said heirs property across each state is different. The center has attorneys embedded within on their payroll. So landowners are not seeking an attorney that they pay for. Whereas some of the other states, the landowner's responsibility is to locate the attorney and find the attorney. And pay the attorney. So there's differences across all 8 or 9 program sites, but the most key piece of this is we took forestry and put it into space with these landowners to say, here are some goals that we would love to share with you. One is ensuring you have a forest management plan. Second, identifying them and helping them to see the entire forestry and natural resource network, all the way down to consultants, the foresters within those states, even the state and Forest Service commissions in each state, other NGOs such as the other SFLRs that can help landowners see that here's the educational component to this particular program. Our key people in the whole project is NRCS, because they had the funding stream, they had the people and the technical assistance, but they were also able to help identify additional funding to certain organizations to help them grow their particular site. And that's how one, being the center, was able to increase the forestry component. And we have some states that have been able to marry up with the Forest Commission as being a teammate. So that's given us more boots on the ground to help more landowners understand that this model can be successful. And this is not a model that you have to build from the endowment. I feel like there's enough work now that's been shared and identified that AFF, being Mavis and her team, can help you launch another program in your town, community, or your state. Thank you, Mavis.
Thank you, Sam. So we're close to concluding our presentation, but we do want to talk about what you can do for Heirs Property. And Sam and I both kind of touched on that a bit, but I do think at a minimum, it's important for all of us to appreciate the history and contributions of family-owned property, owned as heirs property. I think that we often think when we hear the term heirs property, people cringe or like associate it with problems. But I mean, it literally is how most families retain ownership over multiple generations. And our legal system actually makes it more challenging than it has to. So appreciate the history and the contributions of family land owned as heirs property. And then also consider whether you or your organization can do something. And it may not be the legal part, but it could be, providing technical assistance or providing services that the landowners, the heirs property owners, have barriers of access to because of how they own their property. Consider partnering with organizations that are addressing the legal issues related to heirs property. For example, the Mississippi Justice Center is developing, in partnership with the Center for Heirs Property, a program that will offer legal services for heirs property owners in Mississippi. Perhaps there's an opportunity for your organization to provide support on the mapping side or with respect to stewardship of any ag landowners participating in the property. And then asset maps, which we're going to talk about in a minute, but you may be able to create asset maps for heirs property owners. And then money. Money is so important. Excuse me. But there is a need for funding specifically for land owned as heirs property. And I think the USDA has made significant strides and significant promises for funding that I think could be a game changer for heirs property owners who own ag land. So I think that's really exciting to see. But we also need other pools of funding for heirs property owners and for the organizations that are serving them. Typically, the organizations serving heirs property owners are 501c3s, NGOs that maybe don't have the same financial capacity or even human resource capacity to provide sustainable service over time. And so funding is important. Asset maps. Sam, were you going to say?
Before you go there, it's really important for you to think about the one item you mentioned there around funding. There's funding through USDA to do everything as relates to on the ground financial assistance, as it relates to managing land from a conservation perspective. There is no money that USDA can pay an attorney to help clear title. So as you advocate in the work that we're trying to get changed in the Farm Bill, that's where we need your attention, time, and support, because we need additional resources to help landowners who have heir property but do not have the resources to pay for those, the legal resolution part.
Yeah. Yeah, and what you said just made me think another way that you can help heirs property owners is on the policy side. So proof of ownership is typically a big barrier for qualifying for meeting the eligibility criteria for participation in programs that provide technical and financial assistance. So to the extent that you are helping landowners qualify for these programs and see proof of ownership requirements that are exclusive of heirs property owners or would make it difficult for heirs property owners to qualify for, that could be something that your organization advocates to have changed. So asset maps are, Asset maps are visual inventories of the resources available for a particular purpose. So in this case, we're talking about heirs property, and I would center it around a specific geographic area, you know, whether it's a whole state or even a county or a region. And then you're identifying these different resources. It's helpful to categorize them, for example, legal, or businesses and organizations like appraisers, mediators, realtors, surveyors. God knows we need more surveyors. Genealogists, land trusts, conservation groups, drone companies, and then of course government. Obviously, we know on the federal level, we typically have the entities in USDA. On the state level, we have the state foresters, commissions, and organizations, and so forth. But literally, with an asset map, you are identifying the actual entities in these categories and making that information available for heirs property owners and also for organizations that serve heirs property owners. I think another thing that those of us in the green space can do is also provide information about the type of land in the specific geographic area. I know in my law practice, I had a lot of heirs property owners that wanted to do solar, and we know solar has very specific requirements to do solar, but I think because they don't know what the characteristics of their land are and what the suitability is for different activities, it's difficult for them to think about what they can do, and people tend to just say, oh, solar is big, we should do solar. But yeah, asset maps are very helpful, and want to encourage folks to do that as a way of helping heirs property owners.
I'll give you one comment on that particular, the separate project, asset mapping project.
Yeah.
When we started the pilot programs for the endowment, we did not know anything about the asset mapping process, but we built all these organizations out and built the map based on that, and it showed up that we created our asset map in the backwards way versus identifying them up front and saying who do we need to be with us.
And I think that's it. I think we're ready for Q&A.
And there are 4 questions I see in the Q&A box.
Yeah, Jamie, are you okay if I just read out the questions and answer them, or did you want to do it?
Yeah, if you want to read them out and tackle them. I will just simply say that we've had a few folks ask if this presentation is going to be available at a later time. And so just a reminder that yes, it'll be available on our YouTube channel. I'll have a link in the follow-up email that you'll get in the next couple of days. Before you dive in, I had one question, because it kind of takes us back to the beginning. So you guys provided a lot of information, and I felt overwhelmed, and I've got a stake in this in terms of family-owned land, and we're into the second and third generations. You know, it's getting divvied up, or not divvied up, but you know, we're having to deal with this I'm dealing with this in a very real way. So, just if what are a couple of key terms to pump into Google to where, so I have an understanding now of what heirs property is, and that this is a legal thing to deal with. What are a couple of terms that could help me find somebody who's going to guide me forward? And I'll start on the legal side, a couple of terms. You know, what's the type of attorney I'd be looking for? And then
great question. And okay, so I do want to throw out here that there is a book being published by the American Bar Association that's meant for lay people, lawyers, other professionals as well, but it's a whole book about heirs property. And it includes strategies, et cetera, and legal explanations, policies, whatever. But in terms of the type of lawyer that you want to look for, I think it's important to understand first what your goals are. You know, is your goal to do succession planning, or do you have a boundary dispute or whatever? So what are your goals? And then identify, if one of the goals is to clear title, it's important to work with an attorney who is competent and understands the intersection of real estate law and estate law, or, you know, inheritance. And that is a unique mix. And another thing that's important is also identifying attorneys who have the capacity to do this. And so unfortunately, it's more challenging for people in rural areas to find attorneys that have that kind of capacity. A lot of attorneys in North Carolina have rural practices that are generalized. And so oftentimes you may need to look to the more urban areas to find attorneys that have that mix. And it's also for many families necessary to look in urban areas to find attorneys, because unfortunately we've seen in rural areas attorneys in cahoots with predators. So, I mean, that's a very generalized statement, but I just want to name that that's something that, at least anecdotally, I've heard from landowners that have rural ag land.
And Sam, on your side, on the forestry side, so there's standing timber, other natural resources that, you know, I'll just say that I don't know, I can't determine the value. How would I go about finding a forester or somebody in natural resources that could help me with that side of things?
So there's two options. The first one I'll address is going through your state and identifying in the consultant forestry program. They will list the different consultants within the state, sometimes down to the county level. So you can Google for that. You can also contact USDA, NRCS at the state level, all the way down to the county, and look at the county agencies. They have individual technical assistance program people that can help lead you in the right pathway. A third option is for Forest Service in North Carolina, and for South Carolina, I'm just going to pick on those two states for now. South Carolina has the Forestry Commission, and typically there's a county forester at each one of those states that can come out and be the first group of people that can help you on the ground level, that can help lead you to the other two entities.
Okay, and just to recap, for those who don't know, there's a National Association of Consulting Foresters, which is different than the Society of American Foresters. That's SAF is a professional organization. The Consulting Foresters is exactly what the title says. So just again, for those unfamiliar with it.
And then, both groups can help you.
Yeah, and there's overlap too. Consulting foresters are members of SAF.
One thing I wanted to add, Jamie, a project that's being developed by the Southern Rural Development Center out of Mississippi. They're working in the 13 southern states to create what I call a Heirs Property for Dummy manual that is going to be put down to the extension levels on an education toolkit type model to help them be able to lead people in ways that you just asked the question about, how can you get help with their property? It's not a manual to say this is how you resolve it, but it is a manual that can help answer some of the questions that may arise with you or individual family members.
And I'll just, my takeaway really is from, and I'm boiling it down to very simple points, which is do your research on on your attorney and what their areas of practice are, and do your research on who you call in to help with the consulting on the land. Ask for referrals and references, and keep a paper trail as you're going, not only on this side of it, but when you're trying to bring all your heirs together, figure out, because I think very early in the presentation, Mavis was talking about, or one of you mentioned the challenge of identifying everyone who would have an ownership share, especially when you get into that third and fourth generation. There are some questions that I'm going to let Mavis tackle, of course, and read them off. But as tempting as it is to do everything in the cloud or on your computer, it's you know, have your legal work printed out and in a safe place. Just with hacking and corrupt files and the like, we're a library and archive. We have paper backup for everything. So I'm certainly coming to it from that standpoint. But it's really just critically important for everyone to do your research and keep records in printed form. So with that, Mavis, if you want to pick up the questions, I'll let you do that.
Yeah, and again, you know, if you're looking to resolve for your own heirs property, again, having your goals. I think also understanding what your financial capacity is to navigate this, because it can cost quite a bit. And then also how far are you willing to go from an emotional perspective, because, you know, families are dynamic and it can be very emotionally challenging. So I think when you're pursuing to resolve for your own heirs property issues, it's important to be sensitive to that, because you certainly don't want to pour a lot in and then have to abandon it because it just isn't working. So one question in the Q&A is, what about land acquired before marriage and then a spouse? So this is probably going back to the early part of the conversation. And the answer, to give you a lawyer answer, is that it depends. Typically, it's still considered separate property, and there are states that recognize what we call community property. And I'll admit, I didn't learn about it well when I was in law school, because it's so specific, and we don't have community property states in the South, and that's where I practice. Not that I know of. But in terms of the inheritance of separate property, you know, if we have an individual, a married individual that had separate property from their spouse, when they die, their spouse will likely inherit it with their children if they have any descendants. And if they're in North Carolina and don't have descendants but have a spouse and they have living parents, then the spouse could inherit it with the parents. Another question was, what are the rights of children born out of wedlock? How do we call it? Oh, actually, it's a very negative way of saying it in my view. But anyway, children that are not born in marriages still can inherit. The challenge related to those heirs is proving that they are the child. So depending on the state, it could be that the birth certificate informs of that, what we call legitimacy. I don't like that term, but legitimacy, the birth certificate could be probative of that, but there may need to be other measures to prove legitimacy. And so it can get very difficult for proving a or a child that's not born of a marriage as an heir, but they are entitled if that legitimacy is established. So someone asked about LLCs. There's actually a couple of questions about LLCs. So one question about LLCs is, do LLC requirements vary from state to state? Yeah, I don't know that there's a huge variation in the requirements. I do know what is standard for LLCs and other business entities is filing annual reports and making annual paying annual fees to the Secretary of State's office. The Heirs Property book that I mentioned that's coming out later this year, maybe this summer, will have a table that compares the various characteristics of the different business entities as it relates to owning real estate. So it addresses taxation, it addresses management, succession of interest, etc. So definitely recommend that. Also, I have a chapter in it, so that's the primary reason I recommend it. The other LLC question was, I already have an LLC. Could I do a DBA as a tree farm? So doing business as, and this is kind of out of my depth of knowledge, but doing business as, I believe, is simply informing the public that there is a legal name for an entity, but we're using this quasi-fictional name instead. And so it's really just providing some transparency. So I think the answer to your question is yes, but as an attorney, I'll just say it depends on what the state law says. But I think it's pretty standard in all states. Another question that we have is, how can we create asset maps for heirs property? I do think it could be helpful to do this in partnership with others that are perhaps in other sectors, but really it is identifying by category the different resources. Like heirs property owners need appraisers, they need surveyors, they need attorneys, sometimes they need realtors, they may need cooperative extension agents or foresters. So it really is just figuring out what your depth of knowledge of these different providers is in the geographic area, and then identifying them in the map. Someone wants to connect with both of us with additional questions. So Sam, will you put our emails? You can put air shares in there for me.
We'll put that also in the follow-up email.
Oh, awesome.
Yeah.
I'll admit I'm bad at email, or email is not often prioritized for me because I have like 5 jobs. But Sam is very responsive, so he'll track me down. And then someone asked if there's a list of acceptable attorneys and do we vet them. So we don't have a list. I don't have one. I don't know if you have one, Sam.
No,
that would be awesome.
We try to stay away from that. Because we don't, the group that I'm working with and other groups, they don't want the reliability, because it's even in the forestry community, we provide a list.
Yeah. One of our hopes with the Heirs Shares learning platform is, or one of our goals with the Heirs Shares learning platform is to provide certificates as a way of folks being able to say, hey, I've done this training, and they'll know what the training includes, but there's no like licensing or membership body of attorneys who do this work. So it is a bit of a challenge, I'll admit. Yeah, I wish I knew the title actually. I could try to find out. Thank you. And share it with you, Jamie.
Sure. Rosa, thanks for that question. I had the same question in mind.
Yeah.
But it sounds like it's coming out sometime this year, and it also sounds enormously helpful. Between that and the, I think it's from Mississippi, that group that Sam mentioned. If nothing else, it's great to know that this has risen to the level of interest. It tells you there's so much interest that publishers are willing to spend money to bring a book out on the topic. Right, instead of having the lay people having to dig around, sort of the pig looking for truffles in the forest. I appreciate that you guys have taken the effort to bring those truffles together for us and put them all in one place. And you mentioned that you contributed a chapter to that book. Is that correct?
I did. My chapter is on planning to avoid or manage heirs property. So mine is more on the practical side, and there's another chapter after my chapter that's around the business entities that can be used for heirs property. So it's pretty comprehensive. And my hope, Jamie, is that 10 years from now, we've normalized the framing of heirs property and how we address heirs property, because again, most families maintain ownership through inheritance. So I'm hoping that 10 years from now, all of us in this conversation will be very familiar and know how to navigate it and have the resources to do that.
There is a question.
That. Sam, go ahead. Sorry.
Oh yeah. Did you finish that conversation?
I was just simply going to echo that because in the South, anyway, the importance of and the role of family-owned forests, regardless of race or ethnicity or how many generations, the family-owned forests are a huge portion of the land ownership in the South, and having clear title and clear objectives and goals and purposes for that land. Yeah. Sam, I'm just really struck by that anecdote you shared about the four sisters. And what occurred to me with the fact that I'll say it was the grandchildren who looked at it, the land to them was an albatross until it became an asset. And then they were very interested in its future.
Yeah,
and I bet that happens a lot. We hear that frequently in our conversations, informal conversations with private landowners, that my grandchildren they're not interested in the land. They look at the trees and they see dollar signs. So that just adds another layer of complication when you have the generations with different goals.
Yeah, and until I uncovered the sort of that language out there with other landowners and people that are trying to take advantage of them, just from a timber perspective, I didn't realize how big the problem was. And so you think about it in a way that you have all this land and you don't know that it has a big financial opportunity for you. And those four sisters, once it was open to their eyes to see that there's value, they were able to take that and share it with the family, and then they were able to see it as value. But outside of that, families have only seen their land as just an insurance policy, because they were getting pennies on the dollar for what they sold. And there was no one back in the background teaching them how to get the land back sustainably, that it can make money for you in the future. This whole program that we designed with SFLR mirrored that process, and it opened up so many eyes. And now those individuals are out there working in the communities, helping others see it and bringing them to the table for the opportunities.
Yeah, the other thing is, I know from Brett Butler's research on family-owned forests, that just being able for someone like yourself, a forester, or like Mavis, an attorney, to be able to talk to the landowner, there's a difference in just vocabulary. You as a forester are talking about timber or forest, and Brett's research and others have found that if you ask a landowner, tell me about your forest, they don't know what you're talking about. It's oh, I own some woods, or I own some trees, and that could be hundreds, if not thousands of acres, and yet the language was different. So it's even in terms of education, it's getting everybody literally on the same glossary page. So
yeah, it's by region.
Sorry,
by region, says by regions and everything. Yeah. Mm-hmm. And I want to make one point is, we've been sitting here talking about African Americans and heirs property. This is not only an African American problem, and Mavis may have touched on this, but it's widespread. But I want to be able to clearly state that it is an underserved problem because there's a lack of education and knowledge. And part of when we started the program back in 2012, and especially when we rolled it out in 2013, when I was approached to help lead this process, I told them that this is not only an African American problem. We have a lot of landowners that do not know that timber is a resource for them. And those same landowners, just no matter where I am, if they had the physical knowledge and were able to understand the process and use professionals to help them manage going forward, we'd be so much better off with a resource that's very valuable to us, especially here in the South.
Yeah, and that is part of why we wanted the two of you to come on and talk about this, because it's more than one community, more than one region.
Yeah.
And more than one resource that we're talking about as well. So I do want to take a second to thank you guys. Sam Cook with NC State, Mavis Gragg with the American Forest Foundation,